One of the purposes of this webinar is to provide a demonstration of general guidance for people who might be coming across the same topic on the internet. So excerpts of this webinar will be posted on various social media platforms, the usual suspects, TikTok, YouTube Shorts, Instagram, sometimes LinkedIn. So for that reason, plus the fact that it's being recorded, obviously, it's up to you if you want to keep your camera off, and most people are comfortable with that for the most part. So with that in mind, I would like to give a brief introduction. My name is Mr. Max Chaudhary of Chaudhary Law Office. I've been in immigration law since 1993, been licensed as a lawyer since 1995. And I want to avoid giving actual substantive legal advice because this is general guidance. That being said, the format I think that is appropriate that I typically use is people, depending on how many people, there is a chat feature in all of these platforms, including this one, Google Meet, and you can pose a question in the chat. So I believe that's enabled. Let me just see here. Test, please respond with an emoji, for example. People can, paste a text in the chat. What often happens is that, as with any kind of complicated matter, the question would lead me to make some assumptions or inferences which may or might not be correct, in which case you may have to pose more detail in the chat for this. So with that in mind, please feel free to start populating the chat with your question. And then if you have the basis for the question in more detail, you can feel free to please post more detail about your question. If the question isn't given sufficient response that I give you, please feel free to ask a bit more detail to your question. Keep in mind these questions might not be in sequence because people are going to be chatting on top of each other. So I'd be like scrolling through with this. And then after that, hopefully we'll come to some understanding about what is realistic and not realistic in relation to your Canadian visa goal, or if you're in an unfortunate situation where you have to be in some sort of enforcement situation, or if you're in Canada with an asylum kind of situation. I mean, that could also be an issue which you can pose here. So it looks like there's an initial question. So somebody's in Toronto on a visitor visa and need to stay in Canada. So how do I do this? So if we sort of start from the basics, visitor status is a temporary status in Canada. So if you have visitor status and you need to stay, there's different durations. So the initial straightforward format would be to apply for what's called a visitor record while you're inside of Canada. And in most situations, if it's the first time, then they could extend your status as a visitor for another 6 months. Typically, you have to have a rationale for why you're extending and also show you have suitable financial wherewithal for that. So the purpose for the additional, presumably 6 months, plus evidence of money. If you're in Canada, you can open a bank account with your ID, such as a passport. And then if it has money, and the money is your money, that could be good evidence to extend your status on a temporary basis. However, if you need to stay on a permanent basis, repose the question with a bit more circumstances, and I'll get to it since we have lots of time. At this point, I see another question. So it says, I've been working with a work permit since November 2020. Is there any information on the immigration rules about granting me a work permit in the near future? So What I will read into that is whether there is any new policy that might pertain to people who have been on a work permit on a somewhat long-term basis. Keep in mind that in the general scheme of things, people who are on a work permit for more than 5 years or more than 7 years, usually they have to stop and leave for a year. If I recall correctly, the 5 to 7 years depends on the type of work permit you were on. So for example, if you were on an executive level work permit, then I believe you're allowed to work for 7 years in a row and then pause. But if you're on a less than executive level knock type of work permit, then it's 5 consecutive years. And there's got to be a 1-year gap. And that's consistent with the concept of working temporarily. It gets a bit odd under the law and, dare I say, common sense to say that you're temporarily working for like 10 years. That's more like a non-democratic sort of Gulf state situation as opposed to what we associate in a democratic country for this. So the short answer is that the policies that have emerged, particularly since, let's say, October, November 2024, occupied with predominantly cutting off many types of temporary workers, particularly those in the areas where Canadians could probably do the job. And what I'm thinking, perhaps as a parent of 2 children, are those jobs where you're supervising people in a retail establishment, or you're doing, customer service, those kinds of jobs, which a lot of Canadians are bemoaning the fact, which I think there may be some truth to, that wages are being driven down, which is sort of a misapplication of these temporary programs, which is all to say that the pathway for extending work permits now has to have a clear rationale for why the employer cannot hire a local Canadian. And oftentimes that rationale is related to either being in a remote location and or doing something that Canadians don't want to do, like picking worms in southwestern Ontario. Southwestern Ontario apparently has a prodigious quantity and good quality of worms, and a lot of Canadians don't want to do that, and picking tobacco and things of that nature. These are extreme examples, but the focus more on foreign labor, foreign talent, is typically reflected in the occupation list for express entry, which consists a lot of the times these days for healthcare. Teachers are on the list. They've cut off a lot of software jobs because although there was a hiring spree and during the pandemic, now there seems to be a firing spree exacerbated by the use of artificial intelligence, which is causing employers to have no need for low-skilled or minimally skilled IT workers. So working in Canada past 5 years realistically means you probably have to go back for a year and then reapply for a work permit. And in all likelihood, that work permit would have to be supported by an LMIA, Labor Market Impact Assessment, which is the application that the employer submits to a different department, Service Canada, and they vet the assertion of the employer, who is asserting that I can't find a Canadian to do this. I'm thinking of one client, I've got a specialized optical where I can't find Canadians who can grind certain types of lenses, so I have to get this Pakistani fellow who does have this skill, because I've tried to hire Canadians. And the employer submits proof of submitting an application for want ads in 3 different venues, like the Canadian Job Bank and LinkedIn and Monster and all these other platforms, and they submit this evidence. And if ESDC Canada, also known as Service Canada, satisfied, then the LMIA gets issued, then that LMIA gets sent to a visa office, and then you submit your work permit supported by that LMIA. And if the officer outside of Canada is satisfied that you can perform the job and that you will comply with the terms and conditions of that work permit, namely only work in that job, in that employer, at that venue, and leave when you're supposed to leave, then you can return to Canada and work. So that's one scenario. I mean, if you have something more detailed in mind, repost something in the chat, because I'm going to go sequentially based on what I see occurring here in the chat here, right? One looks like more of an enforcement question. So does an ARC application, namely authorization to return to Canada, is a guarantee to get approved? So I'm going to interpret this question meaning what is the likelihood of success for an ARC application? Again, if I'm misinterpreting it, repose it again, but this might give you at least some context. So an ARC application is related to somebody who was deported from Canada in the past. That could also potentially constructively include people who were not formally deported, but they simply left Canada after the time they were strongly suggested to leave. For example, a visitor who had application to restore status, and then that restoration got denied, and then they get a letter saying you must leave Canada immediately. And although no enforcement action was taken, sometimes the person is detected to have left because their passport stamp was, let's say, more than 45 days after that letter, and they did not register their departure from Canada, in which case they would have a constructive deportation order. The ARC is a cure for that. In terms of the chance of success for an ARC, authorization to return to Canada, oftentimes the officer has to weigh the purpose of returning to Canada. So if we look at one extreme or the other extreme in terms of returning to Canada, if you're returning to Canada because you're bald and there's a great guy who does hair plugs and you want to return for that purpose, which is basically a specific visitor visa purpose, that might not weigh as heavily as, for example, the other extreme, where I left Canada, I've got a husband in Canada, he's with my daughter, and there's a psychological report saying my daughter needs the mother, which is me, and the child will suffer, and it's important that I return to Canada. So in that scenario, an ARC chance of success is much, much higher. So those are sort of the edge extreme examples for that. Again, if I misinterpreted that or if there's a follow-up, please let me know. So we have somebody else saying, I recommended in the past investment visa for British Columbia. And the question is, can two partners apply for an entrepreneur program in BC? So I have to take that sort of the question as the ordinary, plain or ordinary meaning, which is when I see partners, I'm presuming business partners. So the short answer is yes. The requirement, I mean, generally speaking, for these entrepreneur programs, and if I think of the rural areas of British Columbia, the financial requirement would be 200,000 Canadian dollars. Oftentimes, there's a de facto requirement to create a couple of jobs, and that would have to be amplified for two foreign nationals who want to invest and manage the same business. There's some variations on this because you could both be partners to purchase an already existing business, and then the requirement would be to expand the business, and perhaps some combination of expanding and maintaining employment and maybe producing a couple of jobs instead of, let's say, 2 jobs per would-be investor. So the short answer is yes, but there's some variations because the lens that the British Columbia immigration authorities are looking at are what's in their economic best interests, and that's primarily, oftentimes to spur innovative businesses or to increase productivity of existing businesses in the province of British Columbia. and the obvious one, which is to create jobs or maintain jobs or to fulfill a need in a more rural area of British Columbia. Let's say they need not just a food desert dollar store, but a more substantive grocery store where nutritious food is being imported and distributed, that kind of thing, just to revitalize communities. So those are sort of examples for that. Let's see, I see something here. Maybe it's related to an earlier question, which is about the work permit. If I recognize the name, the person's posed an additional question. I think it says, I work in a small area in a field of welding, and the employer is interested in me and gave me a job offer. So can you specify the work permit in that job offer? So that sounds like a highly skilled job, because we probably do have a shortage of welders, specialized welders for various types of welding. So in that situation, there's, in terms of the work permit, I'm hesitant to say you don't need an LMIA, just because I know we do have colleges in Canada that train people for this type of thing. And in my mind, that leads to the assumption that there might be some need for the employer to prove that he attempted to recruit people. That method of proving would have to be under the auspices of that LMIA. So what I mentioned earlier, advertising for a period of, I believe, 8 weeks at 3 venues where there are job placements. And then the employer pays the $1,000 government fee to ESDC Canada. They vet the summary of what the employer tried to find in terms of potential welders in Canada and says, yeah, this employer cannot find a welder. And then that employer would say, oh, by the way, I have this person who does have the skills and actually worked for me in the past. And then they'd say, oh, okay, well, there's a small chance they might say, well, did this person transfer any skills to your colleagues? I mean, there might be a bit of back and forth, because if you already work there, if the employer is business-minded, ESDC Canada might say, well, I mean, this guy was good, specialized skills. Did you train anybody? I mean, there might be a reason why that wasn't the case. Maybe the nature of the work required you to not train, but just do your job. I mean, there's some stuff, but basically LMIA and work permit, which is what I mentioned earlier. In this case, and I think maybe the same question related to the fact that the person was in a smaller city. Arguably, that's a positive factor, because maybe welders get trained in public colleges at big cities, and then they want to be with their family, the Canadian trained welders. So that might be something in your favor. That would probably come out in the recruitment efforts, where the employer says in the job ad to the Canadians, it's this much salary. I think it's the median wage, whatever it is in that region, and that it's in this location. And a lot of Canadians might be, well, I don't want to work in that. I don't want to work in this small town north of southwestern Ontario or something. That could be something positive to increase the chance of success for an LMIA, which would be the basis for the work permit. Related question by somebody else, which is, I had an LMIA, but was treated unfairly, and it was dismissed the day the probation was supposed to be over. I guess that's the work probation. And the open work permit under the unfair treatment work permit. Okay, I understand. Okay, this is a very different question. So sometimes if you were exploited by your employer, you can get, I believe, for 1 year, you can get a work permit saying, I was abused on my work permit by my previous employer. And now the whole point of me being here has been completely jeopardized. So can you, cut me some slack? This is sort of the policy-based method to cut you some slack, to give you a vulnerable worker work permit. It's over, this vulnerable open work permit's over in December. Can I get another work permit? I'm at a cleaning business and working in a store. So that policy, if I recall correctly, it's a trial policy. It's been out since 2022 or so. I believe it's only for 1 year. So if I think about it from the officer or the legislation or the policy point of view, they're thinking, well, you got, jeopardized by the work permit that you were under. that permit, not always, but oftentimes is 1 year in duration. We gave you another 1 year as a vulnerable worker. So in that case, that's why the policy is 1 year. There's pathways, but they're very discretionary. And I really would not want to say there's a lot of hope. Sometimes we suggest a consultation, but in a case like this, not everybody is educated. You can do some research, come to a tentative conclusion about what the chances are. They may not be good. If you think the priority is high, then, I mean, we've done discretionary work permits. We filed for one in that exact situation. Well, we don't have the result yet, but we used a discretionary pathway for that, just based on the particular hardship that the person was going under and the country conditions in their home country. But the short answer, I'd say, is the policy says no, but there's discretionary pathways, but you've got to tread carefully with your eyes open about the likelihood of success, which is just a fancy way of saying getting legal advice about that. Another one, different question entirely, is how to overcome misrepresentation in Canada. So the misrepresentation is typically embedded with Section 40 of the Immigration Refugee Protection Act. And we should say it's a material misrepresentation, because some people make a misrepresentation which they don't care about. For example, if you sponsor your father onto the family class, the only criterion is that it has to be your father. If your father lies and says, "Ooh, I got a PhD," and when in fact he's just a high schooler, it's not really material to the criterion of being a parent. So that's a non-material misrepresentation. But to overcome a material misrepresentation, this depends on whether or not we can make a technical argument. So sometimes we say it's not material. That's a bit of a tough argument to make, because the example I gave you was like an extremely straightforward one, where the criteria to enter Canada has nothing to do with education. But more often than not, because I believe the ratio of skilled economic immigration versus family class is something like 65% skilled immigration. The rest is family class and, refugee, humanitarian. So typically the misrepresentation relates to misrepresenting something relevant on your application, which might be like work experience or education. So in some cases, financial wherewithal. So some people, they're in the unfortunate situation where they're in Canada and they hire an agent in their home country to get some proof about something, like their bank or their property or some government document. And the agent, they don't do it the proper way. And then what happens is the agent produces a false document. The person in Canada said, "Oh, I thought I trusted this person in my home country. It's a fake bank document." And then they find out because there's some inconsistency on the face of the document. Or it's a government document and the Canadian visa officer calls the government department and says, "Oh, there's a document serial number such and such. Was this registered with you?" And they say, "We have no record of this government document." So if it's a document where on the face of it, there's a 51% chance that the officer's investigation was correct, that this document was improperly produced or was not properly produced by the government department you're asserting, it's almost zero chance, in which case you're stuck. And then you have to wait till the 5 years elapses and then try again. I mean, there's exceptions where, again, if there's a serious life or death situation, my go-to is always if there's a parent abroad and they have an underage child in Canada, and let's say the guardian of that child is in trouble, then you could maybe overcome the 5-year ban in less than 5 years with a TRP, temporary resident permit. So that'd be one way to cure misrepresentation. But the assumption is that the TRP is typically for a short duration. So it's not like you could start all over. In some cases, you could try. I mean, these are very narrow examples of success where you're married, you've been deported, plus you have misrep. So you need an ARC. Humanitarian. You can make a humanitarian. So anyways, I was going on about misrepresentation and the narrow exceptions to that, right? So another question, let's see, I wonder if this is related. So what's the best route for me, an elementary school teacher, and my husband to apply to move from Canada from the United States? Express entry, PNP, or one of the multiple provinces. So can I apply for express entry and apply for a PNP? So there's a little bit of complexity to this, because when you do an express entry application, I believe this is on the client's portal as well, because we have our own lawyer portal, but you could specify all the provinces. Say, I'm willing to go to any province, and that could trigger an association with most of those provinces. But that being said, in some programs, like I'm thinking of the Ontario employer stream, something extra has to be done by the employer. So the employer registers and says, I want to offer a job to somebody. So that's obviously, you can't simply just register on the federal express entry system in that situation. But generally speaking, you can, if there are these less complex provincial nominee programs where, for example, Ontario has a human capital priority stream, and then they just scoop up somebody who meets the certain work experience requirement, even though it was under express entry. On the other hand, certain provinces, I believe it's Manitoba and or Saskatchewan, have their own federal skilled worker kind of system where you have to meet, I believe it's 40 points. So you have to specifically register for that program to be eligible for that. So you can't avail yourself of that by merely filing the federal express entry application. Those are typically, they call it occupations under pressure in those provinces. Sometimes they might be agricultural sometimes. I don't want to say always agricultural, because once we did one for a civil engineer for Manitoba, they were nice about it. They required him to get licensed, but the federal officer allowed him to come to Canada to write the exam for that. So there's some variation for that. So I hope I answered most of that. I should say also, by the way, if you're familiar with express entry, I think one of the targeted occupations is school teacher. So in the generic sense, if you're, I know this may be unlikely, if you're under 29 with a master's, fluent in English, you could be selected. And let's say with 3 years of education as a teacher. Because if I recall the last CEC draw, I mean, that doesn't apply to somebody in the States. You'd be coming under FSW. But I think the most recent CEC draw was 535, which is really high. But before that, it was like 518 or something. But that being said, there could be some scope. The standard answer of we're all saying, all the lawyers and licensed consultants are learn French and get medium in French, because they have targeted draws for that, which is easier said than done. I think there's a related question from a previous one. I think the person who had the vulnerable work permit, it says LMIA was for 2 years. Okay, so you can maybe make an argument for that. Let's see, the other one is which province has a better chance of getting PR through entrepreneur for me and my business partner? BC, Alberta, or Quebec? So this is, I spoke a lot in sort of bureaucratic governmental terms before about what the provinces are looking for, and it's sort of business common sense, I suppose. But if we come down to what's better for a lot of people, one person I know who helps me with the business plans for these cases, we had a chat about a different case, about a potential worker. We were talking about somebody coming to set up a branch of the business, so not exactly the same thing. So the context is a bit different. But they said Alberta looks a bit better for this than British Columbia. My presumption is that this was related to maybe that Alberta has less candidates, because as you might know if you read the news, I mean, I don't know if you're really, really into this stuff, in 2025, the federal government reduced, I think, by half the allocations for the provincial nominee permanent residency spots. So what that might mean that British Columbia, they're running out of those entrepreneur spots, and maybe Alberta has more available. Maybe because they want to prioritize creation of business more in Alberta. So that's the vibe I'm getting. But again, because businesses are really complex, you're putting in a lot of money. Sometimes another factor to consider is the nature of the business you have and whether it's suitable to be in a particular place in Alberta versus British Columbia. So those are another factor as well to consider. But Alberta might be something to explore in conjunction with the type of business and the previous management experience you have. And I think we have a sort of follow-up to maybe the initial question. The work permit I have doesn't require an LMIA. The job offer is valid. I've applied twice for a work permit before and received approval. So do I have to leave Canada since I've been a temporary worker for 5 years? Yeah, there may be a requirement for this. There may be a need for a pause for 1 year. I think that policy came out in 2014 about this. So you want to make sure that, I mean, even if it does not require LMIA, it might be under the auspices of an international treaty, or maybe, what am I thinking of? Sometimes there's LMIA exempt jobs like intra-company transfer. It could be one of these exceptions, but even still, generally speaking, there's a 5-year and then there's a pause, right? There could be exceptions, but again, you'd want to get perhaps legal advice about that, right? The person about the potential federal skilled worker says 2 master's degrees and fluent in English. The question is, should I apply now, given the age 28? The points, if I recall, under express entry max out at age 29. So you really want to get in at the latest by age 29. Then the points start to drop quite a bit. So that's sort of the short answer. And you've got 3 years of teaching. Okay, so that might be, you might be in the running then, right? So yeah, and I think the 5 years, I think that's generally that's the case. Again, I mean, that policy is from 2014. If it's a make or break worker for you, you should get legal advice, because these policies used to come out systematically and now they come out in a random way. So there's a whole slew of policies in October, November 2024. There might be one now. Maybe there's an exception depending on this. But again, because immigration law is legislation and then regulations and then policy. The legislation doesn't change that rapidly. The regulations change with a bit more notice, a bit more formality, but then immigration is unique because there's a crap ton of policies that come out, which in many cases have the force of law, and it just comes out on their website in very unusual spots, and it's not systematic. So this is one of the big challenges for both applicants and immigration lawyers. We have to keep up on all of these policies, and sometimes they don't tell us until maybe after they've deployed the policy, which means we've filed an application and say, oh, by the way, we've amended this form and the grace period for this is expired. So it's a bit frustrating for that. So another question, sort of a more general question is, can you work while waiting on your work permit? So this relates to status in Canada. And if you are, I want to sort of clothe that question with a bit of a hypothetical. So if you were working in Canada and on a valid work permit, and it was a closed work permit, namely it was for one employer at the same location, and you want to extend that work permit, then you could extend it if obviously you file the extension before the current work permit expires. And then if the conditions are going to be the same, you're working for the same employer at the same location. And then you would have what's called maintained status. You would continue to work on that work permit. And similarly, if you were on an open work permit, which, if you, let's say you're on a spousal PR application, you get an open work permit, you could file for an extension and you could continue working as long as you file the work permit extension before it expires. So that's sort of the general guidance, I'd say. I don't want to say advice because I don't know the exact scenario. Maybe yours is more complex. And I think for our potential FSW candidates, they're posing, if I apply for express entry and invited to apply for PR, how long do I need to move to Canada? So I'm going to infer the question is, how long is the federal government going to take to issue the PR to the person? So the publicly processed time is, well, when express entry was invented, it was supposed to be 6 months. I think it crept up last year to about 12 months, and I think they're going back down to 6 months because there's, to be quite blunt, there's a lot of slash and burn. They're refusing a lot of temporary applications, study permits, visitor visas, work permits. They're getting refused wrongfully, so it's flooding the federal court system with wrongful refusals. I spoke to somebody at a college up north, and they said last year they had 1,200 study permit holders. This year they have 30, which is all to say that when you slash and burn, then the processing times will start to become faster because they're just making decisions willy-nilly, sometimes without regard to looking at the material properly and making a proper decision. So short answer is 6 months. In terms of context to that question, there's a follow-up, which is, do I need to move immediately once I'm invited? Okay, no. In this scenario, because you're applying based on foreign work experience, they understand that you have a life outside of Canada. So once you submit the PR application within 60 days of the ITA, invitation to apply, takes 6 months, they will ask you to submit your passport, and then at that stage, the issuance is coming, perhaps within 2 to 8 weeks of that time. And that's when you really have to make sure you're wrapping up things with your employer, selling big, non-movable assets, things of that nature. If your case is really straightforward, you can maybe take a chance and start to dispose of stuff, before you get the passport request for this. So I hope that gives some guidance. There's a huge issue with misinformation on the internet because part of it is because what I mentioned earlier, which is people post anecdotes on platforms, I suppose like Reddit or I think there's some lawyers have platforms as well for this. And what happens is people say, oh, can I do this? This is my situation. And somebody chimes in saying, oh, yes, you can totally do that. I did that. And then the key fact is that sometimes the fact situation is not the same. Or maybe the fact situation is identical, but the policy has changed. Because as I said, these policies have in many cases, the force of law. And policies are sometimes temporary and sometimes long-term. They're not always permanent for this. So something to keep in mind when you're looking to get some advice about your situation, especially if it's complicated. So by the same token, it's good to get a bit of an idea about where you stand in relation to a similar situation, but don't think of it as determinative of your situation. That's when advice would be necessary. So the other question, I see this looks a bit different, is if someone's on a TRV, so they're visiting Canada, and plans to buy a business like a pizza store, would you recommend C11 or some other work permit for this person? So C11 is really meant for somebody who is going to be an employee at this business. So I suppose if you're a minority owner of this endeavor, you could use C11 for this. That's one concern. The other concern about C11 is that although it does fit if you're an employee, doesn't really have as straightforward a pathway to permanent residency as it used to. The reason is that I believe in March 2025, this year, the extra points under express entry for being, let's say, an executive manager or a supervisor. So you'd get, 200 points as an executive manager, or maybe 50 points extra under the express entry grid. Those points were terminated, and they may not come back until 2026. So people would come to Canada, perhaps get a minority business and be an employee in the business and get the extra points under express entry, but that's no longer the case. So that's something to keep in mind. You could maybe consider C10, which is what's called significant benefit to Canada, which means to Canadian employers or to make jobs in Canada. It's a much more amorphous situation. It doesn't need an LMIA as well. But that starts to blur the lines into like provincial nominee programs, which sort of have the same mandate to have businesses which have the effect of a significant benefit. So that's a really complicated question, but I hope I at least steered you into some sort of specific way to go to scratch the surface in a bit more depth. So I think somebody scraped the policy I was talking about earlier about the duration, and says this policy might have been eliminated in 2016. If you have the link, I can take a look at it later. You can shoot us an email, and I can take a look to see if there's anything that superseded that. Hopefully not. There's a question about medical inadmissibility. Okay, so a very different subject. So how do I calculate me and my husband's medical expenses to determine whether we would be considered excessive demand? So there is every year, the federal government, Immigration Department, publishes their figure for what is the financial number for excessive demand. And I'm going by memory, but I think it's up to like $22,000 per person, and that would include cost of medication and hospital visits or surgery or things of that nature. So that figure, I'm ballparking that figure because I have not looked it up in quite a few months. If, for example, let's say you have HIV and the cost of the medication exceeds that per year, then you would receive a procedural fairness letter stating that we think you have a condition which would cost X amount of dollars per year. And then we'll give you 120 days to respond to this. And you could try to make what's called a mitigation plan, saying, I've got my own source for this medication, or I've got a lot of money for this. So that's sort of one example of how to deal with this, right? So, and then let's see, I think there's something else here. Is there any way to get a small child from outside of Canada while the family is a refugee in a refugee climate and not yet has the hearing done? So I think it sounds like there's a family already in Canada who's made a refugee claim without the hearing being completed yet. Or they have protected person status and they're waiting for the permanent residency. It's a bit vague. You might want to pose the question differently. If the child is part of the nuclear family, then if you're a protected person, you could sponsor that child after getting a successful refugee claim. And then if the family, let's see, on the other hand, if the scenario is that the refugee claim is pending, then that child would have to try to enter Canada. The official way to enter Canada is on a visitor visa. So those are different scenarios. I might have missed the question because maybe more context is required for this. So, and I think a related question to the medical admissibility. So the person does have the figure about how much their medical condition would cost if they were considering the impact of medical admissibility on their success to get PR in Canada. But if they do have insurance, then I suppose the question would be that, is this insurance going to be maintained by you? Namely, you're going to pay the premium. And is that insurance portable? Namely, can it be used anywhere in the world, including Canada? If that's the case, then that could be the good basis for a mitigation plan to address the potential allegation of medical inadmissibility to Canada for this. But overall, the climate now for permanent residency is very, very much focused on what's in the economic interest of Canada. And you see this most markedly with the fact that although under the law there is a program to sponsor parents, it's really been curtailed for the most part, unless you had your expression of interest to sponsor your parent in 2020 or in 2025. There's a backlog of about 13,000 parent sponsorships or expressions of interest, and the processing time is very long. There's a lot of blowback with immigration law and policy because sponsoring parents is associated with increased health costs and things of that nature. So that's another example of the political impact on immigration policy in Canada, which is why you have employer and job market focused targeted draws under Express Entry, like teaching and very niche things like cybersecurity and obviously healthcare, because the demographics of Canada are such that there are too many old people getting sick and ill. So those are the factors at play, which may mean PR is really intertwined with, are you going to enter the labor market in a vocation that we really need for this in the labor market of Canada, right? Again, I guess there's a follow-up related to the medical issue. So I think the idea is when you're talking about medical admissibility, you look at the medical threshold amount that the Canadian government dictates, which I believe is 22,000 or so. And then you try to get a cost of, let's say, the medication. Sometimes medication has generic and name brand, and it's the same thing. Sometimes the generic medication is cheaper. So for advocacy purposes to immigrate to Canada, you want to say, oh, my doctor says I could use this generic medication. It only costs, $1 a pill. I only need 3 pills a month or 3 pills a day. So that's well under the $22,000 threshold. So some kind of research about the medical cost, perhaps from your insurer. They may have like a formulary, I think that's the term, where they determine their costs. And then if it really becomes a factor, then that formulary may be completely inapplicable, because maybe the Canadian government or the provincial governments in Canada have negotiated with drug companies a different fee depending on your age for this. Or maybe the cost of that medication is different in Canada. So it's an exceedingly complicated situation if we're talking about, let's say, the need for a particular medication. It's different, for example, if, let's say, you need imminent knee surgery, and then the cost for that would be well known in Canada, and the solution would be to say, I'm going to get my knee surgery before I immigrate to Canada. I mean, that's a really sort of clear-cut kind of way to mitigate the cost of excessive healthcare on Canada's health and social services for this, right? So with that in mind, still have a few minutes for this kind of thing. So another factor which I want to broadcast widely is that if you are applying for any kind of temporary application outside of Canada, study permit, work permit, visitor visa, As you might know, they're employing artificial intelligence to enhance the decision-making process. This seems to be associated with a sharp increase in refusals of study permits, work permits, and visitor visa applications. And this causes people to maybe reapply for these temporary applications. Oftentimes it gets refused in one day because we don't know, they're not disclosing the system prompts that the immigration department is employing. And they're not really making clear what data they're training their AI on. So they have this project called Chinook, which is their system to use AI to augment their decision-making in temporary visa applications. Since I believe 2021, we're still seeing a lot of unreasonable refusals in this situation. So the factor to keep in mind is that if anything looks slightly off in your application, then what appears to be happening, based on what some litigators who have taken this to federal court, is that the immigration department's AI takes a summary of your application and supporting documents and gives it to an officer, and the officer refuses, and it might be because the summary generated by artificial intelligence is not a true summary of what you submitted. And that's a classic, what we call failure to consider argument, which we have to argue at federal court, where the client says, attached to my affidavit is everything I submitted in my study permit application, and it says my parents have a bank account with an average balance over 6 months of $200,000 US. And the decision said, I can't afford 1 year of tuition, which is 30,000 Canadian dollars. So we say, well, this is obviously a failure to consider the documents. It's gotten so bad that at the federal court, there's a pilot project to deal with study permit refusals. And it's much more streamlined, where you don't have to have all of the formal documents, but just a summary, because these are really simple errors being made by officers assisted with artificial intelligence. So it's something to keep in mind if you're wondering why you received a visitor visa refusal that makes no sense, or work permit or study permit for these kinds of things. So that's another aspect of everything going faster, and the quest for efficiency, and the fact that there are 1 million applications for temporary status to Canada, some humongous number like that. So I hope that's provided some context. Still have a few minutes if there's any question that might be sparked from whatever I've said, or maybe a follow-up to whatever I've said before. In these other kinds of situations, I always want to reiterate, this is general guidance. This may spur you to do some research on your own. If you still don't have clarity, then you can always seek legal advice. This is, again, the call to action to seek out what we call competent counsel. And we have lawyers in our office who can assist you. I'm one of them. And that relates to any aspect of entering Canada, such as these visitor visas, work permits, etc., or staying in Canada in case there's a issue of admissibility and there's enforcement and you're facing deportation from Canada. We also deal with those kinds of things as well. So that relates to interacting with the Canada Border Service Agency more often than the Immigration Department. So again, call to action. You can reach out. I'll just, for the sake of convenience, is the website. Make sure that you check it out. There's a bot on that website. Sometimes you can get some simple answers to your question on the bot based on that, because that website is fairly comprehensive. The caveat, of course, is that you want to make sure that any policies that might be referenced on the website are up to date. So if it's something very critical to you, you may need to get legal advice. So with that in mind, I think we're at time. Thank you for reaching out. I hope this was helpful, and enjoy the rest of your day. Bye-bye.